It's Anderson. Nice to meet you. If we're going to use some blow-ups, where should I put the stand?
That's going to be a tricky deal.
Or are we even allowed to use it?
Well, you are, but only if you... Now, here's the problem. Here's the sticky part. Blow-ups are only supposed to be sticky.
We'll just keep it for soup here.
We're not tired of trying to look at this. Now, with that said, if you want, I'll ask them to waive that particular one. They have it. They're all numbered.
Are you the clerk?
I am. Come on in. Andrew Weber.
Andrew.
Come on in, let me show you how the lights work on our... And you're responding to the deal here, of course.
Yeah, as a matter of fact, because they created both petitions,
Yeah, well, they'll just hear the whole case. You're appearing, Andy Whitaker will go first as the petitioner, quote unquote. You'll go second as the respondent. So that's the way it works.
and then I've got a petition.
Arrest me.
Right.
Just
You're being treated as respondent.
there.
All right.
And basically, if that
I
wasn't
didn't wear the
way
right
anybody wanted
glasses, I'll tell you for sure.
to screen.
As
So,
long as you sign.
so you'll have you'll have your 20 minutes to respond, and that's the way it'll work. He's got 15.
I was waiting. Aren't you glad it's over?
Now,
Yes, ma'am.
this time,
they said that I did some silly things, sir. You know I would.
I don't think you would do that either.
No,
Now,
ma'am.
where do I sit?
Yes, ma'am. You come down there. I'll take that way.
the way this will work is when I kick it on, the green light will come on, and then when you've got 5 minutes left, the sum up light will come on, and then of course when your time up, the stop light will come on. The digital will count down, which is something we don't have at the courtroom in Austin, but for the basic idea is when that comes on, you've got your 5-minute warning, and then when that comes on, it's on. And the court can see the same thing on the other side.
Okay.
And of course, if they want to keep going, you keep going.
Sure.
If not,
Yeah. And so, but there won't be any time for a reply. No.
Right.
Just they're going
Right.
to get 20. They're going to take 15. Then I'm going to take
20. And then they're going to take 5, and then that's it.
Yeah. So he needs to sit behind the bar. I do want you to take notes.
Okay.
And we start up.
We start up at 10, and you're here. No. Yeah, you're. Yeah, we'll start at 10, and I think they'll start pretty much on time. They're already here, so.
Okay, and we're the only case on the docket.
Yes, sir.
Okay. All right.
Our other case was dismissed. As moved down. Yes, sir. I think so. It only blinks once when you turn it on. I don't have this backwards. Petitioner is here.
I think so.
Yeah. Thank you. These guys show up with illustrative exhibits.
I think it's on because I plugged it in. Waiting for the right tick down. Hold on a second. I don't know. Could I have your attention, please? My name is Osler McCarthy. I'm a staff lawyer for the court and the public information officer. The court had a dismissal motion on the second case it set for oral argument this morning and granted that motion. The case went away. What that leaves us with is one case to hear, and so the court rescheduled argument for 10 o'clock. Well, we had buses that were headed this way at 8:30, and so I said I would stand in and tell you a little bit about the court and about the case you're going to hear, and probably in the long run, those of you who are very anxious to get back to school, I know, will probably figure it's a blessing in disguise not to sit through two cases set for oral argument. First, I'd like to ask, is anybody here from Itasca? Yes. I want to tell you a quick story about the Itasca Wampus Cats. My college roommate was from Itasca, and he gave me a Wampus Cats hat. And so when I saw Willie Nelson at Kemper Arena in Kansas City years ago, people would throw Willie caps. Willie being from Abbott, I figured he'd pick my Wampus Cats hat up and put it on, and I'd have a great picture. Well, Willie looked at it and then grabbed another one, and some lady from the audience came up and grabbed my Wampus Cats hat, and I said, no way, that's mine. I'm glad to hear it. I'm glad for you to be here. Anybody here basketball fan? Now, I'm not talking about that fake basketball they play down at American Airlines Arena. I'm talking about real basketball that'll be played in Salt Lake City tomorrow morning between Cincinnati and Gonzaga. So that's the real basketball I want you to pay attention to. I want those of you who are students to skip school tomorrow, watch the Zags, and watch them Saturday when they beat Arizona. But don't put any money on it. I have prepared for you handouts. If anyone does not have a handout, please raise your hand and we'll get one to you. This is a very quick rundown of the case that you're going to hear. It's a very quick rundown of what the court is about. What I'd like to first tell you is that this court is a constitutional court, as most, in fact, all Supreme Courts in the United States are. The court was created for the Republic of Texas in the Constitution of 1836 with 3 judges. For a long time. There was some fluctuation, as I recall, in the late 1860s, and I believe the 1869 Constitution either increased or brought it back down to 3. But until 1945, there were only 3 seats that you would see here. In 1945, the voters in Texas passed a constitutional amendment and increased the court to 9 members, the same number as the U.S. Supreme Court. What you need to know about this court, in the process, when it was a 3-judge court in the beginnings of both the state and the Republic of Texas, it heard virtually everything that came to it. These days, we get something like 12 to 1,500 different legal matters, most of them petitions for review, and the court takes about 100. So what you're looking at today is about 1/10 of the cases that come in the door. The court is looking for cases that in some way, according to 9 different people, because they're all voting on it, they've all got different opinions on it, the court is looking for the cases that will mean something for Texas as a whole in terms of the jurisprudence, the law of the state, where you've got conflicts by the courts of appeals, and that's generally where cases will come from, where you've got conflicts among the courts of appeals. The Eastland Court, the court that decided this case at the intermediate appellate level, the lower court of appeals, and maybe the Houston courts of appeals or the Dallas or El Paso courts. There are 14 in this state. They may decide the same legal issue differently. And so for the most part, the Supreme Court of Texas tries to reconcile these differing views of the law and make it uniform for Texas. Make it uniform for the lawyers who will come in and argue the next case on a case like this where you've got a disagreement over an insurance policy and how to interpret it. This is not a criminal court. The court hears juvenile delinquency cases, which under law are considered civil. But in Texas, and most of you probably know this, but I didn't for many, many years of my life. In Texas, there are 2 Supreme Courts. The Texas Supreme Court and the Texas Court of Criminal Appeals. And they have exclusive jurisdiction over the matters before them. In this case, civil matters for the Court of Criminal Appeals, they have criminal jurisdiction. This will not be a criminal proceeding that you're going to see. It's not going to be like a trial. It's not going to be like you see on The Practice or some of the TV shows. It may not even be interesting. But I hope so. I used to practice appellate law, and I hope so, because here, the fun thing about what you're going to, the interesting thing about what you're going to watch is a court that asks questions of lawyers. What do you mean by that? How do you support that? What's the law on that point? Challenging. And if you'll pay attention and understand some things that are going on about the case, if you'll pay attention, then I think you'll understand how the court is trying to sort out. None of these cases, by and large, are easy cases, or they wouldn't get here. So the court's trying to find out or individual judges, which way should I go? What troubles me here? I've read the briefs, I've looked at the law, I've still got questions. And so if you understand that's going on, and understand some of the points that I'll mention here in a minute, then I think you can better appreciate that this is a dynamic exercise that's going on. And in the end, the law is going to be made on a point in Texas. Now that is what appellate law is all about. No witnesses back here in Judge McGregor has when he's holding court. No witnesses. It's both just lawyers and judges working out the arguments in a case, working out the problems in a case. Now, would like to introduce you, without them being here, and on the back of your forms are the judges. Chief Justice Phillips will be sitting in the middle. He has been on the court the longest. He was appointed in 1988, and then alternately, everything goes by seniority with the court. They probably, in riding the bus up from Austin this morning, they probably sat in order of seniority. So Justice Hecht, on the Chief's right, is the judge on the court who has served next longest. He was elected in 1988, came onto the court in 1989. Judge Enoch, then second in seniority. Judge Owen will not be sitting in this case this morning, but then she's the next. Judge O'Neill, next after her, Judge Jefferson, Judge Snyder, Judge Smith, and then finally, Judge Wainwright. So you see, they alternate this way. They sit around a conference table to discuss cases and sit in order of seniority. One of the reasons for that is that the court is and should be more than just 9 people. The court becomes an institution. The law that was decided years ago ought to be the law to decide the next case. If it changes in increments. It's called precedent. And you may hear the lawyers talk about precedent this morning. So the court gives some deference, certainly deference to precedent, but also deference to seniority. And that's what that is all about. It's not just silliness. I want to also mention, you will hear next from the clerk of the court, Andrew Weber. He'll come up, he'll give you some instructions about the courtroom. Andrew is a constitutional officer, which means his job is in the Constitution. The legislature can tell him he can work for free, but they can't fire him. They can't eliminate his position. Now, those of you who may be keeping close attention to what's going on in Austin these days probably know that we're in a budget crisis. So the court is not going to go on the road. This will be the last, quote, road trip until things get remedied, or we'll stay closer to Austin than what we've been. And who knows, I may not be here even if we come back. Andrew is a constitutional officer. He stays like the court. He will be here. Nadine Snyder is not here, but Nadine Snyder is the mom of the court. She's not a constitutional officer, but since she's mom, then she holds more power than any of us would hope to. Finally, how a case gets here. This case came on a petition for review, which is the common way for cases to get before the court. The Court of Appeals has decided a case that was tried in a courtroom like this, the district court. Somebody at the court on the losing end of the Court of Appeals decision decides, don't want to do that. The Court of Appeals was wrong. I want to take it to the Supreme Court. Realize that the odds are small this court is going to hear the case. So they file a petition for review. The court takes that up. Each of the judges look over those petitions for review. They meet on Mondays, generally every Monday for staff or for court conference. And they'll go around and decide hands or thumbs up, thumbs down on most of the petitions. But if one catches an interest, then one judge may say, I want to see a study memo. And so it'll be on track for a law clerk to take a look at the case. The court will order briefs generally from the parties, more so than what's been submitted, and it begins what becomes a very long process. There's no ruling from the bench. This case won't be decided probably for several months. There will be 9 people working over the draft opinion. If the opinion is issued in the name of one judge, not 8 other judges will have a perspective and in essence will edit it. I don't like this, I don't like that. They work out their differences. Generally, the concern is the court, by issuing this decision, going too far or not far enough? And to watch it is a fascinating process. Problem is, you don't watch it. It's private conference. This case came here because 4 judges at least decided it was worthy of the court's attention, that it was something that needed to be decided, that it had an issue, probably, that had bigger effect for Texas law than just what it meant amongst the parties. That something was there. And what I invite you to look for in what the court is asking the lawyers, what the lawyers are arguing to the court, is what might be there that this court is interested in. Now let me give you a quick rundown on this case. This is, as I see it, I haven't talked to the court about this case. I don't talk to the court about cases generally. As I see it from the briefing, this case comes down to what is total disability under this particular insurance policy, or the 2 insurance policies. Giving you a rundown here. And that's what it is. And it's very typical of what the court takes up. The legislature passes a law, insurance companies deal with clients and make policies, business people and consumers agree on contracts. And then when something goes wrong, somebody looks very carefully and says, whoa, I don't remember that. Or, whoa, that's not fair. Or, whoa, somebody ought to do something about this. And in this case, there is a disability insurance contract. Doctor takes out 2 policies. And they define total disability. I've run down the facts generally in the case, but in the end, total disability under this contract, kind of a key definition, obviously, is spelled out that it means due to injuries or sickness, you are unable to perform the duties of your occupation. You being the doctor in this case. That's the way the contract or the insurance policy language reads. You are unable to perform the duties of your occupation. And so for one side it means, or the argument is, does that mean all duties? And for the other, does that mean any duties? This is what this court does, by and large. It looks at legislation, it looks at contracts, it looks at other matters and parses them. This is not a simple case. Well, total disability means total disability. Not necessarily. And what I suggest is that you think about it in the context of your own, say, automobile insurance. Talking more to you guys upstairs than maybe the rest of you downstairs. You know, where your automobile insurance says one thing, you think it means one thing, and then you may find out that the insurance company thinks it means another. That's what happens in these lawsuits, and that's what the court is here to decide. Now, this case came out of Eastland County from the Court of Appeals. It originated in Dallas County. Generally, cases in Dallas County will go to the Dallas Court of Appeals, the 5th District Court of Appeals. This one was transferred on a docket equalization measure to Eastland, to the 11th Court of Appeals in Eastland. Cases out of Hillsboro generally will go to the Waco Court of Appeals, the 10th Court of Appeals in Waco. And that's the process. Now, finally, you will probably, because these lawyers aren't going to, I assume, aren't going to sit down, aren't going to recite to the court facts the court's already read in briefs. One of the reasons that I prepare these is so that you get some orientation to some of the facts that laid the groundwork for the law that's argued here. And that's what we're talking about. We're not going to retry the case. The lawyers aren't going to talk about, well, the judge got it wrong, the jury got it wrong, except where it's a question of law. So what you need to realize at the appellate level, down in Waco at the Court of Appeals, in Austin before the Supreme Court, the court is interested in questions of law, not questions of fact. Juries decide questions of fact. Judges decide questions of law. The arguments before this court generally are judges got it wrong. Correct the law. Here, they're arguing about summary judgment, whether the judge of the Court of Appeals was wrong in deciding that some of the issues in this case should have been decided by a jury instead of by the judge. The judge granted summary judgment. So you're going to hear that term probably. Another term you're going to hear, and I've tried to define it for you, is Erisa. Big area of pension and insurance law, health benefits. And so you're going to hear about Erisa and whether Erisa preempts state law. You're going to hear fact finder, perhaps. That means juries. You may hear questions of law, what I just mentioned, versus question of fact. One is for the judge, and this court can reach it. One is for the jury. In this case, all decisions at the trial court were made by the judge on summary judgment. He said, you're right, bam, case is yours. And when it was appealed, the other side, no, they weren't right. It should have been tried by a jury. And so it comes up here on some of those issues. So listen for the terms. Appreciate that this, in one sense, can be, in matters before this court, can be quite complicated, but also relatively simple, and certainly affects you down the line. In insurance interpretation, perhaps in this case, in other matters. So that it's not just two people trying to get their day in court. It affects what the court decides will perhaps affect all of us. Now I will turn it over to Andrew Weber. Thank you.
get back as quickly as you can. The court will return after that short break for a couple of proclamations, some questions and answers from the audience, and a couple of other protocol type things. So if you can stay, we would like you to feel welcome to stay and participate in those events after oral argument is over. The DPS troopers may or may not have told you as you came through, but in case they didn't, or if they did, I'll just reiterate our request that you please turn off all cell phones and papers, or if you have a vibrate mode, turn them onto that. Court will, at a minimum, give you an evil eye if a cell phone rings during argument. We don't hold people in contempt usually for it, but they did get a little bit upset. I'm also told that when you stand up, I'm going to open court in a few minutes and ask you all to rise. And I've told my folks that run the court here that when you stand, these chairs have a way of kind of popping back. That's fine when you stand up for that. But if you, for some reason, need to leave for a moment and come back during the actual argument, you kind of try to hold that chair down and dampen that popping, or you'll probably get another evening. I think that's the main thing I need to tell you. If you need to come and go, just do so as quietly as you can. If any of you did not get one of our local things, if you'll raise your hand, I'll get some more upstairs. If anybody's short on it, otherwise I'll get out after the deal's over. Like I say, if you can stay, the question and answer period is often quite interesting and informative, and the proclamations, I think, will be nice for them. So if you can stay for that, we'd like to have you if you can. Unless anyone has any questions of me, the court will be out in a few minutes. Thank you very much for your patience. So these are trial cases. Snake. All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court. Thank you. Please be seated.
The Supreme Court of Texas is honored to sit today for the first time in Hillsboro, Texas, at the courthouse of the county seat of Hill. For 6 years, we have been, pursuant to constitutional amendment, traveling twice a year to various parts of the state to hear oral arguments. Generally, we have also visited with students and with bar leaders and court officials as we make these visits. Due to budget cuts, this will be the last Supreme Court road trip in the foreseeable future. And we think it altogether fitting that we end here in Hillsboro, which is the home to so many distinguished and prominent Texas political leaders. And the one that's nearest and dearest to our court as an institution, of course, is Bob Calvert, a member of our court for 22 years and Chief Justice for the last 11 of those years. Of course, many of us served in state government with Bob Bullock, and we also knew former Attorney General Crawford Martin, and it is a real pleasure for us to be here. Unfortunately, Justice Priscilla Owen was not able to be here. She's in Washington attending to some sort of business, but the remainder of the court is here, and we are pleased to welcome each of you, particularly the students from Hill College and from Abbott High School, Blum High School, Bynum High School, Covington High School, Hillsboro High School, Hubbard High School, Itasca High School, the Mount Com School, Whitney High School, and West High School. And we'll have a chance to visit with some of you later. We had a settlement today, leaving us with only one case to hear. No, we didn't have a settlement. We had a dismissal, and the case became moot. But we are left with one case to hear on today's docket, and that is Provident Life and Accident Insurance Company versus Dr. James Knott. This case originated in Dallas County and was appealed to the 11th Court of Appeals in Eastland. We will allow 20 minutes for each side, the petitioner and the respondent, to present oral argument, and the petitioner may reserve a portion of that 20 minutes for rebuttal by advising the marshal of the court. So we are now ready to hear argument from the petitioner in Provident Life versus Knott.
May it please the court, Mr. Andrew Whitaker will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
May it please the court. The trial court correctly entered summary judgment in Provident's favor, finding as a matter of law that Dr. Knott was not totally disabled from his occupation of gynecologist. In its published opinion, the Court of Appeals acknowledged this court's earlier ruling, or recent ruling in the Cowan case, that insurance policies are interpreted like other types of contracts, that where terms are defined, that is given a specific meaning within the four corners of an agreement, those defined terms should be interpreted as written. But after acknowledging those concepts, the court then went on to completely rewrite the terms of the policies between Provident and Dr. Knott by taking the definition of total disability, which in the policies covers against the inability to do the duties of his occupation, and instead replace that definition with a common law definition covering Dr. Knott's inability to do any substantial portion of the work connected with his occupation. If the Court of Appeals is correct, and if its ruling is allowed to stand, the court has rewritten not only the total disability policies between Provident and Dr. Knott, but it has by extension rewritten all of the occupation-specific policies in force in the state of Texas by ignoring the terms of the policy itself and replacing it with this common law definition. In addition to ignoring the terms of the policies between Provident and Dr. Knott, the Court of Appeals also, erroneously we believe, failed to follow numerous recent decisions from this court interpreting the terms of the policies or terms of a contract as written, reading the contract in such a way as to give meaning to all of the policy's terms, and rejecting as unreasonable any reading of the policy that renders any part of the contract meaningless.
Mr. Whitaker, how do you distinguish this particular fact situation where the courts in the early 1920s, at least, starting in the 1920s, looked at language pretty similar to this and said that, in fact, we're not going to require a person to be totally shut down. How do we determine how much a person is supposed to be incapable of performing his daily duties?
Well, Your Honor, I think the natural starting point is the terms of the policy that have been agreed upon. In the Supreme Court in the Murphy case made it clear that before you do a public policy type of analysis, which I think is what the Court of Appeals did here, you first have to look at the policies itself and see what the result is under those policies. Here we have the interplay, which we believe was absent in the majority of the cases relied upon by the Court of Appeals, of definitions of total disability and partial disability.
Well, I guess what I'm saying is, are you going to require, bottom line, in your definition, that a person just can't perform any duty?
We believe, Your Honor, that the definitions read together in the Provident policies provide that the individual must be unable to do all of the duties of his occupation. Otherwise,
The language specifically says unable to perform the duties.
It does, Your Honor.
Our earlier cases say we have to give that a reasonable construction. You're asking us to put in all duties or any duties.
I don't know that we're asking the court to rewrite it. We're just asking the court to find that in order to be totally disabled, somebody must be unable to do the duties of the occupation. And whenever you look at the definition of partial or residual disability, Your Honor, which cover against the inability to perform one or more of the important daily business duties, or provide for a loss of time.
But doesn't that comport with our early definitions? Because the early definitions said unable to do a substantial portion of those duties, which is more than the partial disability definition, which is one or more.
Well,
They seem to dovetail nicely here. I don't see how they don't.
well, I don't believe, Your Honor, that the earlier cases that the Court of Appeals relied on involved definitions of partial or residual disability. And in fact, they involved entirely different definitions than the definition before the court now. For example, in the Tate and Johnson cases, those cases involved any occupation definitions.
No, I understand there are differences in the policies, but based on your plain meaning argument, when this policy was drafted, we presume that the drafter, the insurance company, knew the common law definition of total disability. And there's nothing here, by saying unable to perform the duties of your occupation, there's nothing here that ostensibly seems to try to do something different than that.
Well, other than the presence of the definition right below it of partial disability that covers against the inability to perform one or more. And I think if
You're saying those are inconsistent. It's hard for me to see how one or more versus substantial is different. I mean, it's the same.
Well, I think that, frankly, Your Honor, I don't know that there's really been any discussion in the cases of what substantial necessarily means. And I think that's one of the problems, that if the Court of Appeals decision is allowed to stand, there are going to be policies across the state that are going to be rewritten on the notion of if you are unable to perform a substantial portion of the work. Is that a qualitative? Is that a quantitative? We just don't know.
Here's my problem with your argument. Had the doctor come into Provident and bought a policy that said, I only want total disability, then it seems to me your argument is he'd be entitled to get that coverage here under a long line of Texas cases. But because he got additional coverage for something less than total disability, which presumably that's a more expensive policy, he ends up getting less.
I respectfully disagree with that, Your Honor. I think by including, most disabilities, Your Honor, tend to be of a short-term or temporary or partial nature. And by buying partial or residual coverage, the individual is actually getting additional coverage by being able to recover benefits if he's only able to work part-time, or if he's able to, say, do some of what he used to do but not all of what he used to do. Under the policies, he gets benefits under the Provident policies that are at issue here. But if he had not elected to get those additional coverages, then he would not be covered against the inability if he was only working part-time, for example, or if there was some duty that he was unable to do.
Mr. Whitaker, part of the, let's assume that part of the function of this doctor for this business, for this PA, is billing, for example. And he can't perform surgery anymore because of back injuries, et cetera, but he can do some of the administrative tasks. Under your argument today, if he's able to do that small portion of administrative task for the job, would he be totally disabled, given that he can't do any of the medical operations?
Am I understanding the court's question that a determination has been made that those administrative or billing types of duties
part of his occupation
constitute a duty of the occupation?
Yes.
Okay. Assuming that they do constitute a duty of the occupation, it is going to be something that makes that occupation what it is. And by virtue of his ability to do that duty, which means he's going into the same office doing some of the same things that he used to do, and presumably deriving some sort of financial benefit from doing that, then in fact he is not going to be totally disabled. And I think
in that regard, Mr. Whitaker, it seemed that one of the concerns of our early cases was not so much that there wasn't other coverage for partial disability or the like, but that to take the statement of total disability to mean not being able to perform any of the duties of the occupation would virtually make that provision worthless. It didn't cover anything because you, I think as some would say, you'd have to be dead before you be disabled. In that regard, in this case, wouldn't that concern still apply, even if the policy still provides coverage for partial disability or residual disability? Wouldn't that concern still apply to the total disability if the court thought that the way it was to be literally read meant that you that if you could perform any function of being a doctor, then you'd have no coverage. And as a result, that provision would never be reached short of the doctor being an invalid in bed and not literally being able to function at all.
Well, I think one difference, Your Honor, between the older cases and this case is the focus on the word duties. And that is, it focuses on what it is that makes that occupation what it is. Certainly, it is not difficult at all to come up with circumstances under which Dr. Knott would qualify as totally disabled, but still be able to do some of the tasks that he used to do.
Well, he could consult in gynecology. He could be a quadriplegic in a wheelchair and not even be able to speak, but if he could tap out the notes on a typewriter and look on a video screen, he could consult. And that's one of the duties of being a gynecologist. So he would not be totally disabled from the reading of the statute, but he'd be partially disabled because he could not perform one or more duties.
Well, admittedly, that's an extreme example, Your Honor, of one possible result. But I think that what's important to note about the consulting aspect of it is Dr. Knott advised us that consulting was one of his duties. But I think distilled to its essence, the duties of the occupation of gynecologist may well, properly defined, not include that. That is, there may be a way, and certainly an insurance company who takes that position, that that a doctor who is physically disabled from doing any aspect of what he used to do, other than possibly typing on a typewriter or a computer, denies that claim at its peril, basically. And I think one way around that is to seek refuge in the policy, to say what are the duties of this occupation? What makes the occupation of gynecologist what it is? And I don't think there's any question that performing surgeries and seeing patients are going to qualify under any set of circumstances as the duties of his occupation. And what we have here is a doctor, Dr. Knott, who at all times has been able to see patients and at all times has been able to perform at least some types of surgeries.
I'm unclear what your position is. If he can't perform some essential duty of the occupation, then what is your position? He can, let's just make it easy, there's A, B, C, D, and E, and he can do A, B, C, and D, but he can't do E, and you can't be what he is if you can't do E. Is that total disability or not?
Well, I would think that is not necessarily this case, because
I want to ask you about that in a minute, but first of all, with respect to the definition, if there is an essential thing that you can't do, but you could do other things, which maybe are essential or not essential, but there's one essential thing you can't do, then does that meet your definition of total disability?
I would think if properly analyzed, Your Honor, there was one duty, and the doctor was unable to do that duty.
No, there's multiple duties, but one of them makes the job what it is.
The duties from which the other duties flow.
Yes.
Orthopedic surgeon who cannot do surgery.
Right.
I would think that doctor would be totally disabled, Your Honor.
And then there is no dispute in this record that he cannot do some things. Is that true?
There is no dispute, Your Honor, that there are certain, for purposes of summary judgment, that there are certain surgical procedures that Dr. Knott is unable to do.
And so now we're talking about how broad is the category of the occupation, perhaps. And because if any one of those surgical procedures was essential to his occupation, then your position would be he's totally disabled.
Well, I would analyze it, Your Honor, in terms of duties. And I would, again, rely on what the policy says about that term. And the policy says duties. So I would analyze surgery as being duties. If Dr. Knott is unable to perform certain types of surgical procedures, but can, and we in fact know he performed other types of surgical procedures, he is not unable to perform that duty, therefore not totally disabled.
But if we define the occupation as microsurgery, we define it down so that it includes, so that one essential part of the occupation is something he can't do, you would say he was disabled.
I mean, assuming for purposes of your hypothetical, Your Honor, that his occupation entailed the performance of only one type of surgery, which he could not do, from which all of his other duties flowed, then I think duties of his occupation, he is unable to perform those, because surgery is the duty of that occupation. And that's why I think I tend not to want to get too sidetracked on, the extreme case of the person who could do the, shuffle the paperwork or, clip documents together, because I don't think properly analyzed that is a duty of that occupation. It may be something that he did, but it's not going to qualify as a duty of that
How would
occupation.
you define the duty of the occupation? Is that a question of law, or does the jury decide that?
Well, I think if the facts are undisputed as to what the individual was doing, I think it becomes a question of law. I mean, here,
Again, to follow up on Justice Heck's question, at what level, how far down do you define what the duties are? Do you define categories of surgery, or do you divide it surgery, consultation, administrative? How do you come up with categories of duties?
well, in the first instance, we check with the plaintiff. In one of the forms that we send a plaintiff at the time, or an insured at the time they want to submit a claim, we ask them, list the duties of your occupation. Here on that form and during his deposition, Dr. Knott repeatedly identified having 4 duties: surgery, seeing patients, consulting with physicians, and performing administrative duties. For purposes of this analysis, we will adopt his listing of his duties as being the duties that he provided.
What if, under the surgery duty, you did perform 100% of what you did was the type of microsurgery, and after the disability, you can't do that anymore, but you retool yourself and do some other type of surgery?
He would at best, Your Honor, qualify as residual or partial, which covers against the inability to do one or more of your material duties. So if Dr. Knott was unable to do the surgeries that he used to do and was suffering an income loss, he would potentially qualify as residually disabled. And if he's lost income, during the changeover to his new type of surgery, he would be entitled to residual disability benefits up to age 65.
You're not saying that he has to be unable to perform all duties in order to be totally disabled, are you?
We are saying, Your Honor, that due to the presence of the definitions of partial and residual, that he must be unable to perform the duties, which means all.
Well, then can you explain your footnote in your petition, footnote 9, which says that you are not making that argument? Are you taking a different position now?
That footnote was put there by me. That footnote was in error, and I apologize for the court. When we were before the trial court, we said he needed to be unable to perform all. We said that in our summary judgment motion, summary judgment brief, and that was what our corporate representative testified as well. So that is solely a situation of my making, Your Honor, and I apologize for that.
So let me just understand so I can put it in simple terms so I can understand it. Michael Jordan goes and buys a total disability policy. He gets unfortunately hurt in the car accident, and he can't dribble. But he can shoot free throw shots, and he can shoot jump shots from any place on the court and hit just as well, but he can't dribble. Is he not entitled to any
Well,
be totally disabled?
I think you would define, I think that would go back to Justice Hecht's question earlier. If he is unable to perform one aspect that prevents him from doing that occupation in its entirety, if he could not dribble, for example, then he is unable. But I don't think, Your Honor, in that situation that you would parse duties down to include, every little single thing that he did as a basketball player, because you would look at what the duties of the occupation truly entail, and the duty of the occupation is playing basketball.
Can we take your company's payments from 1996 to 1998 as an admission that his condition at that time was total disability?
I don't think so, Your Honor. First of all, under this
Let
court...
me expand that question a little bit more before you answer it. Did Provident seem to send mixed signals to Dr. Knott? Your position is there was a denial sent in 1986.
Correct.
Then there's a waiver of premiums from 89 to 95 suggesting total disability. There's agreement to pay Dr. Knott from 1986 to 1989, again suggesting total disability according to Dr. Knott's position. Was Provident sending mixed signals?
I don't think so, Your Honor. I think what Provident was doing was bending over backwards in a customer service move to provide benefits that Dr. Knott would not otherwise be entitled to. We let Dr. Knott know in February 1986 that because he was working on a part-time basis within that 90-day elimination period, he was not totally disabled. But to bend over backwards to Dr. Knott, we added a residual disability rider, which he had declined to apply for, that enabled him to get benefits. And so for that first 3-year period, we were providing benefits that he would not have been entitled to absent our good faith decision to add a residual disability rider. In 1991, when we resumed billing Dr. Knott for the premiums, Dr. Knott complained of that decision, and we sent him a letter, which is in the record, where we said, we don't think you're entitled to the waiver of your premiums, but as a customer service move, we will agree to go ahead and do that. And that's what we agreed, that's what we did from that point forward. Then returning to Justice Phillips' question, from 1996 to 1998, Dr. Knott advised us on his initial claim statement that he was not working. I think now we know a little bit more about Dr. Knott's activities during that 1996 to 1998 time period, that if we had been, if we knew then what we know now, we might have had a different result there. But we went ahead and took Dr. Knott at his word and went ahead and paid him for that entire period. But we paid him for that period because he told us that his disability arose after his 65th birthday, which meant that he was only entitled to the 24 months of total disability benefits at that point.
Mr. Whitaker, you've explained what you believe is a good motive for bending over backwards, as you've called it. Notwithstanding your motive, does that still create a potential reasonable difference of opinion as to what Provident's conduct constituted? Was it a denial that there was total disability, or could a reasonable fact finder have looked at the and said, irrespective of what may be, in your terms, a good motive, that the signal was sent that it was not a denial of total benefits?
I think, Your Honor, we have been consistent since the letter in February of 1986, telling Dr. Knott that if he is going into the office as a gynecologist, doing some, if not all, of what he used to do as a gynecologist, he's not totally disabled. And the fact that we took steps to give Dr. Knott the benefit of the doubt, I don't think changed that fundamental premise. You know, in terms of waiving the premiums or in terms of providing them residual disability benefits, those were done by agreement to accommodate Dr. Knott. And in fact, the fact that Dr. Knott did not receive total disability benefits from 1986 through to 1996, I think speaks volumes about the message that Provident was trying to send at that point in time.
Do you think there are limits on what Provident could have done after sending that 1986, I think what you've described as a denial letter, that would have taken Provident's position from arguably not one of agreeing there's total disability to one of there is total disability? In other words, are the things Provident could have done after sending that letter that would have meant that de facto it was not in agreement with the letter that there was total disability?
Well, no question. I mean, instead, in response to Dr. Knott's complaint about that letter, we could have said, you're right, Dr. Knott, you are totally disabled, and we will resume paying you total disability benefits.
Short of that, is there a line that this court can look at as to where to draw Provident's statement as compared to its conduct?
Well, I think the only aspect of conduct, Your Honor, that I think is inconsistent with the position announced in February 1986 is the point made by Justice Phillips regarding the payment of benefits in 1996 to 1998. I think the other events, when they're analyzed in the context in which they arose, were not a admission by Provident that Dr. Knott was totally disabled at all. I think to the contrary, they were saying, we think you are not totally disabled, but we are going to go ahead and accommodate you in this way. And I don't think it's good policy or good result to punish Provident or somehow stop Provident at this point by virtue of those good faith decisions that resulted in benefit to Dr. Knott.
Tell me how you think this opinion should read. We should say that the plain language of the policy says that you have to be unable to perform the duties of your occupation, meaning all duties of your occupation.
Well, I don't know necessarily, Your Honor, that the court has to reach that point in this opinion. And let me tell you why. The policies do cover against the duties. Okay, duties appears in the partial, total, and residual definition, and it is undisputed that there is no one single duty that Dr. Knott is unable to perform.
Depending upon how you perform, how you define duty.
Well, Dr. Knott told us that surgery is one of his duties, and the policy does not cover against the inability to do procedures. It covers against the inability to do duties, and we have a surgical log that shows that Dr. Knott performed more surgeries in the 7 months after the plane crash than he did.
I'm still trying to figure out how you would write this opinion as you're unable to perform the duties of your occupation. Surgery is a duty of the occupation. Undisputed evidence is you could perform some surgery, therefore, plain language, no total disability.
That would be fair, Your Honor. And I don't think the court has to go any further than that if it is so inclined.
Any other questions? Thank you, counsel. Court is ready to hear argument from respondent.
May it please the court, Mr. Ben Martin will present argument for the respondent.
May it please the court. I would like to take this opportunity, getting off of my original outline, to address, if I could, some of the questions that the court had this morning from Mr. Whitaker. I would first address Justice Wainwright's inquiry regarding the mixed messages and the mixed signals that Dr. Knott was given. In fact, he was given mixed signals. Back in 1986, he was put on waiver of premium. Waiver of premium, in accordance with the policy definition, means that they are considering him to be totally disabled. What they additionally did was, in their internal documents, had indicated he is to put on permanent waiver of premium. This was 1990-1991, at that time period, on both policies, because he had a continuing total disability. At the same time, they had initially, and I'll talk about this in a minute, Your Honor, the initial denial, which we take the position was certainly not an outright denial, was withdrawn effectively a month later when Provident said, you really don't owe us this money back that we previously last month said you do, because the only reason could be because we're putting you on waiver of premium, we consider you to be totally disabled. At the same time, they give him an illusory benefit. The illusory benefit, in effect, takes away from him the conception that he can, in fact, or perception that he can, in fact, do anything. Because they're saying, what we're going to do is we're going to consider you totally disabled, and we're going to give you this residual disability rider, effectively paying you for being partially disabled, yet at the same time telling you you are totally disabled.
And he didn't complain for 10 years about that.
He didn't complain for 10 years, Your Honor. He did not. There's no evidence as to whether or not he is taking the position that back in 1986 he should have.
My only point is the estoppel argument can work both ways. He took the partial disability payment and didn't say anything about it for 10 years. So there's some level of estoppel there as well, I would think, if we're going to go an estoppel route.
Well, we do not think that Provident can put an insured in the position of giving him an illusory benefit. Even though he is a doctor, he is an educated individual, they are in a superior position to tell Dr. Knott, for instance, look, we're going to give you this benefit. It was, in fact, not a benefit. It was a detriment, because Dr. Knott was indeed entitled to total disability benefits if, in fact, he was totally disabled. So we are not saying that there is evidence that conclusively establishes or otherwise establishes, because it's not an issue in this case, what his disability was back then, which is why we take the position on the statute of limitations issue that he didn't file suit until 1996 or 98 because of the fact that at that point in time we said, yes, he can no longer do anything effectively.
Let me ask you how, if you look at, it strikes me that the old cases where we interpret this language didn't have partial disability definitions in them. They were total disability policies.
Sure.
I'm having a hard time figuring out how we are to construe both of these together, which admittedly would have to do. Can you tell me what the difference is between inability to perform one or more important daily business duties versus a substantial portion of the work?
Yes, Your Honor. First of all, the cases all indicate that it is a jury question, first of all.
I'm talking about legal definition.
Right.
In terms of where, not
Surely.
how the facts line up under them, but
Right.
just conceptually, what's the difference between a
Absolutely.
substantial portion of the work and one or more important daily business duties?
I think they're completely compatible and completely consistent. One, the jury could think, okay, what are what is one or more important daily tasks or important tasks of the occupation, which is the partial definition. There's certainly a major qualitative difference, I believe, between one or more important daily tasks and then the substantial or material duties of an occupation. For instance, in this very case, one or more daily tasks might be some administrative tasks that he cannot do. He may be considered partially disabled for that. But I would point to the fact that the evidence, contrary to Provident's position in this case, is the fact that there is a multitude of surgical and non-surgical things he cannot do. The evidence, as pointed out in the brief, is he can't do any microsurgery. He could have done it before. He can't do any obstetrics that he was considering going back into because of Dr. Kuhn's withdrawal from the partnership. He can't do most laser surgery. He was unable at all to perform any vaginal surgery, and he can't do any surgeries involving bending.
Let me ask you this question. If he was able to do any sort of surgery before that required a lot of physical activity, and after the injury, he was somehow precluded from doing very physical sort of surgery and could only do microsurgery, which was much more lucrative, and he ended up tripling his income. Under your argument, he would still be entitled to total disability for the rest of his life.
Well, total disability is not income determinative. So that would be the first response. The second response is, if the court is looking at the facts of this specific case, in fact, the opposite is true with regard to his microsurgery.
The argument, I mean, it could work the other way. It could work the way I've posed it.
The other way being, could he make more money and still be totally disabled, essentially?
Working full-time in surgery, doing a different type of surgery, making 3 times the money, and still be drawing total disability.
I would think that would be a possibility. However, I do not think that it would be a very good case to put in front of a jury. I mean, truthfully, that's why I believe that it should be a jury question, because of that very case. I don't know that in a matter of law he would be totally disabled under those circumstances.
Every case is a jury case in your view?
Every case, unless it is conclusively established.
But you just said it couldn't be.
It couldn't be conclusively established. I think it would be very difficult. I think it would be very difficult for a situation to arise where on either side an individual could be considered totally disabled or conclusively established that he was not totally disabled, especially when the fact issues are presented in this case. And
when a person goes back to work after an accident and is doing something like what he was doing before, position here, and is fully occupied and making more money than he was making before, you don't usually think of that as totally disabled.
Well,
under any definition.
I can say this, that in this particular case, there were occasions where he was making more money. There were occasions where he was making less money. In fact, the insurance company paid him very few months for this residual disability because, in fact, he was making slightly more money than the 20% loss that he was incurring. He had, at times, greater than a 20% loss in income, and in fact, they paid him the residual disability benefits.
But it seems to me your argument says that if, unfortunately, as a result of the plane accident, he had been crippled and really could not show up for work, he would be in the same position vis-a-vis this policy with respect to the benefits as he is if he can do everything except perhaps one kind of surgery.
If the one kind of surgery is considered to be in accordance with Supreme Court law for 80 years now.
But doesn't that strike you as odd that total disability would encompass everything from you can't move, as Judge Enoch said earlier, you're almost dead, to you can do everything you could do before except maybe just this little bit?
No, Your Honor, I would disagree for the reason that I think that it is inconsistent for the definition of partial disability to encompass everything except laying on your back, unable to do anything. That's what I think is more bothersome.
Let me follow up on Judge Snyder's hypothetical. If you had Michael Jordan who couldn't dribble, he can no longer play basketball, then he goes and plays baseball and signs a great big contract to play baseball. Does he draw full total disability?
I don't know. I don't know. But I will say this, that I think the chances of Michael Jordan not being able, for a physical reason, to not be able to dribble and still be able to be a Major League Baseball player would be so rare that it shouldn't work as a disservice to an individual like Dr. Knott because of the circumstances in this case. Those aren't even close. If I could respond to the example, I believe the example would be if Michael Jordan couldn't dribble, and therefore dribbling is a part of the professional basketball game such that I suspect he couldn't play at all. But he could go play exhibitions for a few minutes and make money playing exhibitions at a high school gym or college gyms, for instance. He would probably make a lot of money, I suspect. Michael Jordan would, but he's not able to dribble. I think in that certain circumstance, Michael Jordan certainly should be entitled, because he has lost any substantial material duty, he should be entitled to recover his total disability benefits for which he paid, and in this case, for which Dr. Knott paid for many, many, many years.
Do you agree that your client would have been better off only to buy a total disability policy?
Absolutely. Absolutely. However, with this particular insurance, with Provident, if they acted as they did in this case, it wouldn't matter if he bought a total disability policy. I suspect they could have, again, given him, to use the term that Provident likes to use, a residual disability rider. In fact, and then could take that residual rider on the total disability policy and use it against him, just as they're using it against him today, and just as they've used it against him throughout.
Give us an example of, within the confines of this fact, of what you believe partial disability would have been.
Okay. From memory, when he filled out the duties of his occupation, what they were for prior to his plane crash, I believe there was something like 30% was a certain type of microsurgery. 30% was maybe another type of laser surgery, for instance, which I believe is different actually than microsurgery. A certain percentage was endoscopic procedures, and then a smaller percentage were administrative duties. A partial disability might be that he could see, and he was seeing, I think, 25 patients. This is a very good example, I think. He was seeing, I think, 25 patients prior to his plane crash where he broke his back. And afterwards, he may have been able, if he had been able to see, because of the fatigue involved, he may have been able to see 12 patients or 15 patients. And he was still able to do his surgeries. But you know, maybe if he did one surgery a day, an hour and a half surgery, he could still do that. But because of the fatigue involved, he could see only a certain number of patients as opposed to the number he could before. I believe that would be a situation where he could still see patients, couldn't see as many of them, and that would be, I believe, a case where he could be entitled to partial disability as opposed to total disability payments.
You also think, under those same facts, he could also be totally disabled?
If the jury were to consider that the patients, that the numbers of patients that he was unable to see in his physical condition, and with the medical testimony that would be at hand, the jury certainly could, and I believe should be able to make a determination as to whether or not that is a material or a substantial duty of his job.
You said a moment ago
you are
that
in a difficult situation in this case. It appears to me, on the one hand, your client client would like to have the total disability determination occur prior to him turning age 65, because then he would get lifetime benefits. On the other hand, if that determination goes back to prior to August 1995, when your client turned 65, then you may have a problem with the statute of limitations, which the Court of Appeals talked about. Since there's no precipitating event in 1995 or occurrence that led to the disability claim in 1996, you've got to kind of bridge that gap. And it is a tightrope walk. You walk that rope?
I would respectfully disagree, Your Honor, that it's a tightrope. I feel confident.
What kind of rope is it?
I think it's a wide plank.
Okay, well, tell
And I hope it's a plank going into the ship as opposed to off the ship.
Should have said plank.
Now, Mr. Martin, tell us how you walk that plank.
Could I ask the court to repeat the question?
To make it simple, on the one hand, if
Got it.
you're looking at a 1985 determination of total disability versus a statute of limitations argument that may cut your claims off.
Certainly. The key in this case is that he certainly could. One of the points the court, Your Honor, has made is, well, what about the fact that he didn't have a precipitating event? That's our very point. He didn't have a precipitating event. I'm not talking about the plane crash, but I'm talking about a precipitating event between the time of the plane crash and the time he sought disability benefits and filed suit in the late 90s. Because that supports the argument, in fact, that his disability, and Your Honor, it's not total disability that must commence before age 65. The policy says disability that commences prior to age 65. So his condition did, in fact, I believe the summary judgment evidence is, worsened to the fact that he, I believe the wording was, couldn't do it any longer. So he gets, at that point in time, he makes a determination to institute suit, file a claim, institute suit. Your Honor, we are not seeking any benefits, nor have we ever sought any benefits for any total or partial disability that went unpaid prior to the time that he filed his lawsuit. In fact, they had paid him total disability benefits for 2 years and stopped paying him total disability benefits, I believe, when he turned, I can't remember his age, but it was past 65. That's why I don't think it's a tightrope. That we're not seeking any benefits that the statute of limitations would be applicable to at all in this case, nor have we ever.
Let me ask you, you mentioned a moment ago that total disability is not income derivative. And so somebody who could be totally disabled and yet make a substantially larger income in the general area of the person's occupation. Where does that statement come from? Is that pursuant to your construction of the policy, or are there cases that you rely on for that?
It is pursuant to the policy itself. The policy has no there's nothing in the definition of total disability that deals with income. There is, if in a residual rider case, which is or a partial disability case, there are income determinative aspects to it. As a matter of fact, it's mostly income determinative. But he bought this policy with the provision of total disability that if he was unable to perform, quote, the duties of your occupation, close quote. And I would like to point out, if I could, to the court, these three Texas Supreme Court cases, 1920, 1931, I believe, and 1961, those cases dealt with what actually used to be the language in Providence policy way back when, until changed. They changed it twice, and it used to be that if you were unable, that the policy said you must be unable to, I believe it's to do any task in your gainful occupation. It used to be what the Bryant case and what the Tate case and what the Johnson case actually, I would use the term overruled, as against public policy to have that type of language in the policy, because you would never be able to have a total disability claim. They, in two or three separate occasions, and they call it this, significantly improved the definition of total disability. They took that definition of total disability away. Now, I would make the argument that what they are trying to do is to get this court to submit or to insert a new policy, to insert a new definition that goes back to essentially what the law was before 1920. And I'm sorry, Your Honor?
I asked the court if there were other questions. I've got just one more, just a series here. Now, are you contending then that this insurance contract is ambiguous?
I am not contending it's ambiguous. I'm contending that its definition it comports with what the Supreme Court on several occasions has indicated is the definition of what it means to be totally disabled. The duties of the occupation, and my time is up, but as set out previously in our briefing and as set out previously in the definitions that the Supreme Court has given us in the past, is consistent with the new and improved definition that Provident gave Dr. Knott.
Well, under your argument then, could the parties ever come up with any contractual language to define total disability other than that contained in our common law?
I believe there is probably I believe that the Supreme Court has outlined a good rule. I believe that there is language that could be constructed that's somewhat between what the new and improved definition in Providence policy is, the duties of your occupation, that they would like to read as all of the duties of your occupation, and what the Supreme Court back from 1920 has said is language that we can't live with. I believe there is a
So if this definition of total disability said unable to perform all duties of your occupation, you think then the parties would have contracted around the common law language?
I believe that would be essentially the same language that the Supreme Court throughout all of these years has said it can't live with. And I think the Supreme Court would have to change the law in that.
Disability then becomes a common law definition regardless of what the parties contract for. That is what this court has done on 3 separate occasions, as outlined that is what the court has done in the past. So based upon that, I would say the court would have to do it in the future, but not for this definition and not in this case.
Do you think that's an appropriate method of construction, interpreting the contract?
You mean if we had the old definition that
we have a contract that has specific wording to then import a common law definition into that contract that may not be consistent with the wording of the contract? Is that an appropriate way to construct
I think it is
a contract?
I'm sorry, Your Honor. Yes, I think it is appropriate in the circumstances that this very court has talked about in the past, that the Supreme Court has talked about in the past, where you've got a case where someone contracts for something that they really don't get a benefit from, which is what the court in Johnson said, the court, I believe, in Tate said, and the court in Bryant said is, you're contracting, you're getting paid money as an insurance company for a benefit that doesn't exist.
So it's an illusory contract.
That's what I would say. Those definitions are in fact illusory as far as anybody being able to get a total disability benefit in the state of Texas.
Is there anything in the record about the price differential for this? If it's a rather rare occurrence to be totally disabled, it should be relatively inexpensive to add. Is there anything in the record about the cost difference between requiring insurance for total disability and partial disability?
Yes, I believe, in fact, there is, shortly before Provident gave Mr. Knott its, bent over backwards and gave Mr. Knott its benefit of the residual rider, it was sending him advertisements for the residual rider, and it cost about $100 a year for the residual rider, which I would assume would be some evidence of an economic benefit of the residual rider that in this very case actually took away a benefit from Dr. Knott. And his total disability benefits, I can't remember the exact amount, but they were it's much higher to buy a total disability policy in this case than to buy a $100 residual disability rider.
I just have one more. I just want to make sure I understand your position on this. If the parties had a contract that said, we've adjusted our premium and taken this into account, this policy is going to have various levels of coverage, or we're going to define total disability very restrictively. You have to be completely incapable of doing anything. And we're going to define partial disability and residual disability. We're going to break these definitions down, and this is taken into account in the premium. In your opinion, would then the common law cases trump total disability definition there?
If the insurance company is getting paid for total disability, if they're giving the illusory benefit of total disability, or if they're giving a benefit and it's to be determined, and it is in fact not going to be an illusory benefit, then the Supreme Court has to stick with the language. Okay, I misunderstood.
Posit the contract that says total disabilities, you can't do anything.
Okay.
Partial disability is something less. Residual disability is something less.
Right.
We've broken this down. We've taken it into account in the premium. This is our agreement. In your opinion, total disability would still be bound to the common law definition, yes or no?
I just have to, when you say it's less, you mean less money to buy it?
Yeah, no, the contract just says this has been taken into account in the policy payment.
Okay. I believe that in fact is done in this case. I believe in fact you pay more for something with a residual disability and a total disability.
So I just want to make sure your answer is yes, the common law definition would usurp.
Yes, it would.
Any other questions? Thank you, Phillips.
Thank you.
Marty, ready to hear rebuttal.
Mr. Whitaker, isn't it true that neither your client's position nor Dr. Knott's position on the definition of total disability is stated explicitly in this contract? Neither one is stated explicitly in this contract.
Well, I believe ours is, Your Honor. I think to the extent adding the word all of, would be another way to write that to make it.
But all of is not in your, policy provision.
I agree completely.
So then we're going to have to look at something and follow some appropriate statute or contract interpretation tenets to figure out, in the context of this contract, which definition, which position, or some other position is right and just and appropriate. What is it we should look to and follow in your opinion?
We cite the court to the Roush opinion, Northern District of Texas, Judge Lindsey. Judge Lindsey faced a similar situation, interplay between total and partial. He said because duties is plural, it implies you're unable to do more than one duty if it's just analyzed in a vacuum. And then he said further support for that conclusion is found in the definition of partial, which covers the inability to cover one or more. I think Provident, and not Dr. Knott and not the Court of Appeals, is the only party that can actually give meaning to both the definitions of total disability and partial disability and read them in such a way as to give meaning to all the terms. This court has, in a series of cases that we cited in the briefing, set forth standards of construction to follow in contract cases. And they include, among other things, giving meaning to all the terms, not reading out any part of the definition, and only reaching public policy grounds once you have examined the contract to see what result yields.
Let me ask you that. So you're distinguishing the old common law cases, the old Texas Supreme Court cases, based on policy language that contains a definition of partial disability.
Among other reasons,
Okay.
yes, Your Honor.
So if this were only a total disability policy, would you agree that the definition in the old Supreme Court cases applies?
I would not, Your Honor. I think
we would
that,
have to overrule those cases to go your way.
well, I don't think so necessarily, Your Honor, because those were any occupation policies. And so they cover a different, using different language, okay? And I think that the notion that there is this body of insurance out there, disability insurance, that should have the wholesale importation of this common law definition into it, even though that's not done in life, auto, health, any of the other cases that this court has recently decided and articulated these standards of construction. I'm at somewhat of a loss to understand why disability insurance should be treated differently than all those other types of insurance where we just wholesale rewrite the language.
You don't have to rewrite the language, do you? If partial disability is the inability to perform one or more of the duties of the office, and total disability is to be unable to perform the duties of the occupation, the duties of the occupation doesn't necessarily mean all, but it certainly implies a substantial number of the duties to the point that you can't adequately perform the occupation. So, I mean, the duties of the office doesn't say all the duties, but it certainly implies a number of duties that you can't perform. It wouldn't be totally inconsistent for the court to say total disability is the substantial inability to perform the duties of the office. It's not inconsistent with that language.
Well, I would think, Your Honor, on these facts, the same result may be reached. That is, because Dr. Knott is only unable to perform certain types of surgeries, that as a matter of law, that does not constitute a substantial part. And so in some circumstances, you could get to the same result. My problem with this, Your Honor, and I think it's something that Justice Smith and Justice O'Neill were focusing on earlier, is there are different policies out there in the marketplace today at different premium rates, which have presumably, if Texas law is being complied with, have been submitted to the Texas Department of Insurance for either approval or the opportunity to disapprove, and which probably didn't exist because it was created in 1951, didn't exist back at the time of those earlier policies that the court, on the earlier opinions that the court issued. And if the Court of Appeals and Dr. Knott are correct, it doesn't matter what those other total disability policies say in its total disability clause. It doesn't matter what rates have been charged. So I think if the Court of Appeals is correct, what the smart consumer should do is go find the cheapest policy that has the most difficult to meet definition of total disability and is priced accordingly, armed with the knowledge that, as a matter of cases decided, a long time ago, all of those are automatically rewritten to include a definition that is much more favorable to him. And I think that that notion is just completely inconsistent with all of the recent opinions of this court in the insurance area, giving meaning, at least taking a look at and seeing if you can reconcile and make sense of the definitions themselves.
I assume you wouldn't deny that this provision basically lacks clarity and or specificity. So to the extent it lacks clarity or it's not specific, should it be construed in favor of the doctrine?
I think that the doctrine the court's referring to of contra preferentum isn't reached until the court has made the threshold determination that ambiguity exists. And in order for ambiguity to exist, there have to be two reasonable interpretations offered. To date, I don't think either Dr. Knott or the Court of Appeals have offered an alternative explanation for how total and partial disability can be read in conjunction. Instead, the Court of Appeals position is just it should be rewritten in toto. So I don't think we have a situation, Your Honor, of
it lacks clarity or that it lacks specific.
I think whenever you read,
it's ambiguous in any
I think that argument has not been raised by anybody to date. And then I don't think whenever those definitions are read in conjunction with one another, which, by the way, Dr. Knott applied for partial disability at the time. I mean, he was able to see back at the time what partial disability would cover, and he applied for and obtained a policy that said he would be partially disabled if he were unable to perform one or more, but not all, important daily business duties. And that was from the get-go.
You're saying his initial application before the 90 days had run, that you turned down because of that, was merely for partial?
No, Your Honor. The point I'm making is back in 1970 and 1974, when he applied for coverage, we added the residual later. I'll grant Dr. Knott that, but he applied for partial coverage, paid an extra premium for partial coverage, and knew when he got the policy that that would cover him against the inability to perform one or more, but not all, important daily business duties.
Thank you, counsel.
Thank you.
What has been an honor for the court to sit today in Hillsboro. This is the first time we have ever sat in a trial court, even as a Supreme Court, even though 6 of us were trial judges at one point in our career. As I sat here and looked at the history of the court, I was reminded that two justices who served on our court were earlier in their careers district judges here in the 66th District. Nelson Phillips, who went on to be Chief Justice, and Sam Johnson, who worked at our court and then served on the Fifth Circuit United States Court of Appeals. And Ms. Johnson is here today. June, we're delighted to see you. Also, this courthouse is very important to the state because the tragedy of its burning and then its rebirth started great public interest all across Texas in our courthouses and in preserving these courthouses. And we're here really at the first of the great restoration projects. And so while we're saddened by the fact that until the budget condition of the state of Texas improves, we will not be visiting any other locations outside of Austin, we're certainly delighted to have been here today and to have heard this argument. And after a brief recess and some photos, we will look forward to visiting with the students about the justice system in our state. That concludes the arguments today, and the marshal will now adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned. Thank you. For those of you who can remain for the proclamations and the questions and answers, please do so. The court will be back in about 5 to 10 minutes. Thank you.
The green, yellow, and red?
Yeah, in Austin we only have green and red. But the green comes on when there's nothing on, and then the green comes on when you have 5 minutes left, and then the red comes on our little traveling tour we had this week.
So does the question by the justices count against your training?
Yeah, it does. And that's one of the most...
I didn't know whether you were keeping up with it.
No, that's one of the most frustrating things. That's why there was a woman over here, Nina Portel, who came to sit today and watch because she's arguing the case next week. Many attorneys who haven't seen the court often do that at that time because they want to see, what, in the legal vernacular, the question is how hot is the panel? Hot panel starts fire on the question. And it can easily, not only eat up your time, but throw you off track because you came to talk about this, but of course they want to know about this, and next thing you know, you spent your 20 minutes and you're going, oh, wait, what happened? So, yeah. Turn it to the side.
I was taking off.
I don't know if he does, he'll pull it over. What? Good to meet you, Judge. I'll go. Ready? If I could have your attention for just a moment, please. If you could please take your seats, the court will return to the courtroom now. Thank you.
No, photos are after this.
Oh, they are?
They want to do them outside.
Oh, okay.
This is, we're doing
So we're,
resolution.
so we're, I'm starting.
I'm sorry, I didn't realize.
We're back, and the photo session is later, right? Okay, got it. We'll have a brief bit of ceremony here before we take questions. I'm going to call on two people and then recognize some folks in the audience, and then we'll talk with the students. First, I want to recognize the mayor of the city of Hillsboro, the Honorable Will Lawrence, who has a presentation.
Justice Phillips and Honorable Justices of the Court, we so welcome you to Hillsboro, Texas, and to this historic courthouse. And obviously, you've done some homework before you arrived. You know our history, and we value that. Thank you. On behalf of the City Council of Hillsboro and all of our citizens, we not only welcome you, but we thank you for celebrating with us the sesquicentennial of Hillsboro. 150 years ago, this town was laid out, and we have seen since that time so much development and historic growth in this community. And as you have mentioned, we think we have been an incubator, really, of leadership in the state of Texas, and we appreciate your mentioning Justice Phillips and Robert Calvert and Sam Johnson. Today, I present to you this certificate. I will not read the proclamation to you. I'll spare you that. But it is proclaiming today as Texas Supreme Court Day in Hillsboro, and it is saying thank you for celebrating with us the sesquicentennial and for helping to make a new chapter in our history. We value you and the work you do for justice in Texas and for your contributions to good government. And it is my pleasure now to present you this key to the city. It's also the key to our hearts. It won't operate any other equipment. But it is a symbol of our appreciation to you and for this proclamation that we hope you will file in the annals of the court and know that you are, even though you may have budgetary restraints, we hope when you can, you'll come back to see us and share in the life of this community. Thank you, and God bless you.
Why don't you approach the bar? Thank you very much, Mayor. We have a small memento case in the foyer of our court, and the proclamation and the key will go there. Next, we want to recognize the County Judge of Hill County, Judge Kenneth Davis.
Justices, we thank you for choosing Hill County, the location of the most beautiful courthouse in Texas, to conclude your tour of these fantastic cities in Texas. And we do appreciate the honor, and we're very honored and humbled that you did come to our beautiful courthouse. And I won't reiterate what's already been said about the great leaders that have served in this courthouse and then gone on to state service as well and practice, because that speaks well for itself. But we do appreciate your recognition of that, and thank you for being here. And we also have a proclamation that we want to present to you, and I will read this one a little bit. There's a little bit more to it, if you don't mind. Whereas it has come to the attention of the undersigned county judge and commissioners of Hill County of the state of Texas that the Supreme Court of Texas will convene at the city of Hillsboro in Hill County, Texas on March 19th, 2003 at the Hill County Courthouse in the 66th District Courtroom. And whereas it is fitting and proper that in this sesquicentennial year of the County of Hill, as well as the city of Hillsboro, that this court duly recognize and honor the Supreme Court of the great and sovereign state of Texas, and whereas the said county is grateful to the said court and its staff for the great honor of selecting Hill County as an appropriate place to hold a session of said Supreme Court, especially given the said 150th anniversary of said founding, and whereas Chief Justice Thomas Phillips, Justices Nathan Heck, Craig Enoch, Priscilla Owen, Harriet O'Neill, Wallace Jefferson, Michael Snyder, Stephen Smith, J. Dale Wainwright are all distinguished jurists of the Supreme Court of Texas and great Texans all, and are worthy of this official welcome to our county. Be it therefore resolved that the undersigned county judge and commissioners of Hill County, Texas, officially proclaim Wednesday, March 19, 2003, as Supreme Court of Texas Day within said county, and call upon citizenry within Hill County to welcome the Supreme Court with due courtesy, respect, and gratitude for the High Court electing to come to our courtroom and hold court on that day, and that a true duplicate original of this resolution be delivered unto the said Chief Justice, and that this resolution be duly spread over the official minutes and records of Hill County, Texas by the Honorable County Clerk of Hill County, Texas, Ruth Pelham. Issue our hands at the city of Hillsboro, County of Hill, state of Texas, on this 12th of March, 2003. And this is signed by Kenneth Davis, County Judge, J.K. Lane, Commissioner Precinct 1, James Busby, Commissioner Precinct 2, Mildred Brewstrom, Commissioner Precinct 3, and John Irwin, Commissioner Precinct 4. And again, thank you for being here.
I believe this is the first time we've ever been officially recognized by anybody as great Texans, so we will we'll cherish that designation, and maybe we can use that in court in our defense someday. We want to thank the Hill County Bar Association for their work in making today possible, and in particular the current president, Mark Pratt. Mr. Pratt here. Thank you for your help. and the Hill County Sesquicentennial Committee, and the chair, Cleo Davis, for your efforts and the mugs to come. Thank you. Hillsboro Masonic Lodge 196, which loaned the chairs that are the reason some of you are sitting and not standing. And the Hillsboro Chamber of Commerce for chairs that we'll get to sit in later. Sheriff Brent Button and his staff for their help with security, parking, and audio-visual services and making this visit very successful. Honorable James A. Showers and his staff for their help in coordinating the event. The flowers were provided by Governor Bill Daniel, who, of course, is from Liberty, but is Hill County by marriage due to... We appreciate the media in attendance, and the ones who we've identified are Art Mann from KHBR Radio and the Reporter newspaper here, and Mr. and Mrs. Ron Eubank from Lakelander newspaper in Whitney, and Barbara Mintz from the Hubbard City News, and Judy McClure from the Itasca Paw Print Press. Thank you all for... We have found that our coverage improves as we get away from Austin, and we hope that's the case today. We appreciate Judge Robert Dahoney for his work on the history of the courthouse. Judge Dahoney, good to see you. And the District Judge's Office, Linda McCullough and Susan Villarigi, is that? I messed that up, and I was trained, but I still messed it up. And Dr. Auvenshine, the president of Hill College, and the superintendents, all 12 of them in Hill County. We appreciate your attendance here today. Would they stand? So we can, would the superintendents stand so we can see? Where you, right. Okay, somewhere else. And finally, certainly not least, our host and our inviter today, the Honorable Bob McGregor, current judge of the 66th District Court, for giving us his courtroom and all his hospitality. Judge McGregor, incidentally, based on last year's statistics, was the busiest district judge of all 418 in the state of Texas. I understand also that Ms. Margaret Martin is here. Is that right? Yes. So good to see you again. And Ms. Johnson, it's always great to see you. And we feel a real connection with the history of this county and with our court by your presence here today. So we're very grateful for that. Now, we can't tell you anything about what we thought about the case we just heard. Of course, it is to be hoped we're thinking a lot, but as judges we act deliberately. One of us has drawn this case to prepare a draft opinion, which we have to circulate within 3 months or bad things happen. Well, not too bad, but we get on a list inside the court. And then we'll talk about it at conference. And if people disagree, they may take the case and write a dissent and try to turn that a dissent into a majority by convincing 4 other judges to go with them. But this is a process that takes several months, and since we're the Supreme Court, we try to have a premium on getting it right rather than just getting an answer out. And so we won't, with due respect, answer anything about our impressions of the case, the strength or the weaknesses, or what the lawyers did right, or what if anything, they might have done wrong. But beyond that, anything about the work of our court, or the justice system as a whole, or somewhat more dangerous grounds, but state government, we would just open it up. And should we stay, is it the plan that we stay standing here, or do we have a better plan?
Come sit down.
We're standing, we're not sitting.
You may sit. No.
That's great. That's the right answer.
No, let's sort of explain that earlier than they did.
So if you have a question to a specific judge, you may so direct it. Otherwise, if you just direct it to the group, I will will lateral it off to somebody. Who will be the first? All right.
Well, they can ask what
Where's
size
the-
bus we drove in on, or you can ask how long we've been here.
Yes. Yes, ma'am.
Play it back later and listen.
Yes, the question is, do we record the proceedings? And we do. And I'm sure these were taped today, but always at home we make a tape of them, and then we reduce that to a transcript. And there may come a time, so some courts are doing this already, where we place all of our arguments on a simulcast on a website. At one point, there was going to be a text span network like C-SPAN that asked to hear our arguments, and we said fine, but the money was not forthcoming. But I know the Florida Supreme Court broadcast. But what we have now is we tape these. Of course, all of our arguments are open in Austin, and then we make a tape of that argument, and you may purchase a tape of any argument for $1 from the clerk of our court. $5? I thought that was for the video. I've been saying it's a nominal fee all along. Well, the clerk has to make a profit too. $5 will get you a copy of a tape of any court argument. Yes, sir. We don't have any limitation by law. By custom, we generally start hearing arguments the Wednesday after Labor Day, and we stop taking arguments sometime in April. We used to go a little later, but now we generally try to stop taking arguments in April and then work as hard as we can to dispose of that docket before we take a summer break sometime about the 4th of July. And this calendar is determined primarily by when our law clerks are with us. They take the bar exam in July and then start with the court in the middle of August, and they serve for 1 year with us and leave the 1st of next August. So the goal is to dispose of all the cases we hear in a year by the end of the calendar year. We've never met that goal, but that's our goal.
Can I add something to that? I just have to get this in. Our summer recess is the biggest misnomer I have ever heard, because it doesn't resemble anything like recess. We stop hearing arguments, but then every week we're still reading petitions to decide what to take the next year. We're working on opinions that we haven't gotten out before. The court is still very much at work during the summer months, but we're just not hearing oral arguments in cases.
Let me add, too, that since my father was a minister, it's like he used to have to answer why the church was vacant the rest of the days of the week. He only worked on Sunday. It's kind of like that. Okay?
Chief?
What are the requirements for you to become a Supreme Court judge?
The requirements to be on the Supreme Court. Somebody want to pick those off? Okay, I'll say it then. You have to be 35 years old and currently a lawyer in the state of Texas and have been a lawyer for 10 years. And you have to file and run for the office unless you're appointed to a vacancy. And you have to be under 75. No, you do not have to have prior judicial experience. And in fact, Judge Calvert, for one, who was from Hillsboro, had been Speaker of the House of Representatives of Texas, but he ran directly for the court from out of private practice and was elected. And three of our current justices came directly out of practice. The three over there. Yes. How about arbitration and the move towards it?
Well, if I understand the question, some interest in mediation and arbitration and that sort of thing outside the court, the students might be interested in this. To become a lawyer in Texas, it takes 6 years of college and law school if you go to some schools, and takes 7 if you're going to other schools for your law school degree. So when you talk about being a judge, one of the qualifications is you got to be a lawyer in most of the levels of the judiciary, which requires an extensive amount of education beyond graduating from high school. But the courts also are strongly supportive of mediation arbitration, which are alternate methods of resolving disputes rather than just going to court. And there's a whole group out there that are working on mediation skills and arbitration skills, and in certain phases of that legal occupation doesn't necessarily require a law license. And so you have paralegals who are evolving in the practice of law, who are assisting lawyers and the process of representing clients on legal issues that we do recognize certifications as paralegals, as an example. One of the other aspects in the law is these mediators and arbitrators who can be experts from particular fields of vocation that are not necessarily lawyers, who will be deciding those kinds of questions outside of the courtroom sphere. The idea it'd be a lot less costly for individuals and for businesses to resolve their disputes if they don't rack them up and start shooting each other in a courtroom. And so there's a large career area that's evolving out there that doesn't require a law license, and those tremendous number of years of education that is available for people who are interested in the law, interested in issues, in resolving disputes. That doesn't require you necessarily to have all the qualifications and actually sit as a presiding judge in a case. When I was in high school, we had a kind of human relations commission, a peer review or a peer resolution deal. Are any of the students here involved in peer dispute resolution in their high schools? Do you have any of those programs here? Well, it's very big in a lot of the urban areas on peer resolution issues, and so there's another area where I got my start in interest in law. Actually, was serving on a peer resolution group when I was in high school.
Well, the law of the state of Texas is supportive of the notion that any other way you can resolve a dispute other than going to court is good. There's a lot of encouragement of people with disputes to try to figure out ways to solve those. Our court tried a mediation procedure among cases that had already gotten to our court, and there was not much enthusiasm for that. By the time people had been through a trial and to the end of the trial and been through an appeal to the Court of Appeals and it concluded that and it comes to the Supreme Court, they were kind of locked into litigation. So you mentioned the numbers. We do get about 1,500 cases a year trying to get in our court, and we take about 100 of those, and they all seem to want to be there if they lost below.
My question is not specifically directed to any one person, but it's with regards to the recent increase in Homeland Security. Do any of you believe that our First Amendment guarantee of freedom of speech should be abridged at times of war? And also, should we de-emphasize due process rights in order to boost Homeland Security?
One of the junior justices wants that.
That is a very good question, and a very and also a difficult question, and a question we have to sidestep. Issues of constitutional rights and due process that citizens of Texas and the U.S. have, and whether they've been appropriately abridged or not under our Constitution, could come before our court for a decision. And I believe it's inappropriate for me to give an opinion about how we might decide that at this point in time. Of course, we all are human beings, even here in robes. That might surprise you. And we have opinions, but we set those aside when we get up here on the bench, become a judge and rule according to the statutes and the Constitution and try to follow that consistently as written. So our personal opinions we have set aside, and I think there are situations where it is inappropriate for us to give our personal opinion about issues that are likely to come before the court.
And Chief, if I might add, though, this is a great time to be a student of democracy in many ways, because you see how the various sections of our government work, the executive branch and the legislative and the judiciary. There are times when they have to step in. They're, in the end, one of the grand protectors of constitutional rights. And so you will see in the weeks and months to come issues just as you presented going before courts for resolution. Many of them will go before the federal courts instead of the state courts, but I'm quite sure that we will be seeing some of those questions ourselves. And one of the great benefits of our democracy is at the appellate level, once we reach a decision, we hand that down in writing, and we subject it to criticism from lawyers and judges and politicians all across the country. So it's an open system, and one that you will be able to analyze just as we are obligated to do as judges.
Let me also add that this isn't the first time this issue's come up. During the Civil War, the issue came up about whether or not President Lincoln could basically suspend or rid of habeas corpus. And it is a problem that I just didn't want you to think it was unique to this time in history. It certainly raised its head in both world wars, and as you know, even in Vietnam, the issues and about peaceful protesting, or the issue of whether or not they were helping, quote, the enemy, unquote. Okay. Yes, I see.
I wanted to know what the procedure would be to convert our system of electing justices to appointing justices.
Well, the procedure is to go to a different system of choosing judges. Would take a constitutional amendment, which means a 2/3 vote of each house of the legislature, and then a vote of the people during some election. And there are changes in the way judges could be selected that would not take a constitutional amendment. Like the legislature could go from a partisan election like we have now, Democrats and Republicans, to a nonpartisan election, like the way you elect your mayors and school board members. The legislature could put caps on when and how much money you can raise, or they could even provide for a public funding scheme like North Carolina just did, where the lawyers, the occupation tax that lawyers are charged goes into a fund that candidates use to run for office rather than raising money directly. But to change to a system where every judge is initially appointed and then stands for a re-election race on a yes-no against their record or serves until a certain age, that type of change would require a constitutional amendment, because our Constitution says the judges of our court are to be elected every 6 years. And there is such a move now in the legislature. But it's not assured of passage.
Do you have an opinion to electing judges as opposed to appointing them?
Well, yeah, there's always going to be some kind of an election, but right now, close to half of our judges in Texas are appointed anyway by the governor. About half of I think 5 of our 9 judges here were initially appointed when a vacancy occurred. So we already have appointments. And the type of elections we have depends on whether or not you get a challenger. And as we mentioned earlier, you have to be a lawyer of a certain age and requisite amount of practice to run. So about 2/3 of all judicial elections are unopposed now. So that's the system we have now, and it's partisan. I would prefer a system where every judge was initially appointed and then they ran on a yes or no ballot at the end of each term. That's called the retention election system. About 20 states have retention elections, and depending on how you count it, between 4 and 7 have partisan judicial elections. About 12 have nonpartisan elections, and 10 have some type of appointment system. Round numbers, but roughly correct. So the states have not agreed on a uniform system of how to choose their judges.
Chief Justice Phillips has worked very hard on this issue for a long time, and if you look remotely interested, he'll tell you about it.
She did.
And I think the Supreme Court's website has a bunch of my speeches on there, because if I give them to the legislature, they have to put them up. And so you can read more about it and write your legislator to agree with me.
My daddy used to say that the enemy of the good is not the bad, it's the best. And judicial selection is one of those unique problems where it's very easy. Looking at this room right now, the vast majority of you would probably say that the partisan election of judges is not the way judges ought to be picked. Okay, we can all agree to that. But then when you start asking about, well, then what process should you have, then any process has its own difficulties. And so it's very easy for everybody to split on what's the better or the best process, and that tends over the long haul to ultimately stymie any real effort to improve the selection process of judges, is because we break down in battles over what we think is the better of the changes, and so that tends to stymie it. I'm not sure I understood the question, but I think you have to begin with one of the premises that a society always has the right to protect itself. And so when you get into this concern about homeland security, the courts historically, as Justice Snyder talked about, as you look at some historical examples that have happened, the courts have tended to give a little bit more leeway to the government's efforts at protecting the homeland that they might not give some leeway to if the homeland was not threatened. And so what you're seeing in all of the press and reports and the politics that's going on now is at what level of balance do we go? To what extent does the U.S. Supreme Court, as an example, begin to give some leeway, or the federal courts, because many of these issues really come through the federal courts now under the U.S. Constitution, in this determination of just what deference does the court give in this notion of protecting the homeland. And so we're seeing a lot of that debate going on, not just in the courts, but we're seeing the debate going on in the halls of Congress. Do we want to pass this law, or do we not want to pass this law? Have we gone too far? Haven't we gone far enough? So that's the debate. And so I don't know if that answers your question about how the police enforce this. I mean, it's a very scary thing when just a citizen can go into a nursery and buy over-the-counter products that you use every day, and they just buy it in bulk, and they pack it into a panel van, and they drive in front of a federal courthouse in Oklahoma City and blow the building away. It's a very troubling notion about how you can ever control that kind of conduct in an open society like our own.
Had all of you not become justices, what other possible careers would you have chosen? And would there be any possibility that any of you in the future would y'all ever run for political positions such as maybe governor or even something like president?
Well, I would have been Tina Turner, no question. Well, no, we have a lot of people go from our court into other types of public office. We had our new Senator, John Cornyn, left the court to run for Attorney General and then U.S. Senator and was recently elected. We have our new Attorney General, Greg Abbott, who was on our court. Al Gonzalez, who was on the court when I got here, is now the White House counsel. So there are many areas to go from the court, for sure. This is sort of where I feel the most comfortable. I've been a lawyer for a long time. I was a district court judge in Houston and a court of appeals judge in Houston, so it's an area that I feel the most comfortable with, but Who knows?
For years, well, for about 100 years, this court tended to be kind of the last step on your career. And in the days when the elections were generally, it was all one party, everybody was a Democrat, and once you got in office, you were seldom opposed. People would kind of work their way up a ladder. And that's, as you can tell by looking at some of us, though not all of us, that's sort of changed. Our court has gotten progressively younger in the last 10 or 12 years, and so not everybody wants to stay here 30 or 40 years, as much fun as it is, and some have left and gone in, well, it started, I think, Judge Doggett ran for Congress in 1994 from Austin and was elected, and then since then we've had 4 others go into some other type of public service. And that's a little unusual in our history. When I got here, we had 2 former congressmen who had ended up at the court. But it's sort of the nature of the change, the increasing partisan elections, or the contestability of these Supreme Court elections has made younger people do it, I think. And younger people are going into the judiciary all over the state. Partially it's pay. At least in the large cities, a beginning salary for a lawyer is greater than any judicial salary in the state. So younger people are getting here, and they obviously are a little more mobile, or tend not to stay. If you come to the court at 65, it's easy to stay till you're 75. If you come in your late 30s, something else may happen.
All right. We all understand that Supreme Court justices are elected. Does the party or the platform that you stand on when you're elected, does it sway your decision on what cases you see or what you might decide on different cases?
I think this is safe to say that nobody has ever read the party platform. And if we did, no, it wouldn't sway us, because our obligation is to the law and to apply the law. The party platform really speaks to, if it speaks to anybody, it speaks to candidates for the legislature who are running on specific promises of this what we'll do in office, vote for us, and you can expect this to happen. Somebody just yesterday said the job of the legislature is to make the law for all the people. The job of a judge is to take that law that's made for all the people and apply it to 2 people at a time. And so our function's quite different. We don't impose our personal belief systems or how we think things ought to be. We take the law either as the legislature has made it or prior court decisions. Today you heard a lot of talk about prior court decisions and how we would apply those decisions to the case before us. But we're not looking at a party platform and saying, okay, you win and you lose because the Republican Party likes you better.
Well, and although we do apply it to individual litigants, our guidepost is whether a case is important to the jurisprudence of the state, because we're a discretionary review court. So we'll review the cases and we'll try to decide, is this a case that's very fact-intensive, that just affects these parties? It's not going to be important to a lot of different people. We're more likely to deny the case because it's been through presumably a trial and one level of appellate review before it gets to us. But we tend to look at cases and grant those cases that have more universal application, a statute that needs to be interpreted that will affect a lot of people. Our interpretation will affect a lot of people. If you have 2 courts that are in conflict on a particular issue, 2 courts of appeals, we're more likely to take that because we need to resolve that conflict. So we look for cases that have a broader application at our level.
Your question, I think, is a very good one, a very sensitive one. Because judges are not representative elected officials. The 21,000 voters of Hill County voted on the judges. Hopefully everybody voted for the judicial positions and didn't stop before you got there. But when we take the bench, unlike a legislator, it's not our job to take an opinion poll to decide how a case should come out or what the law means. Yes, we're responsible to the state elected by the people, but our job is to look at the Constitution and the law and apply it fairly and consistently, in my opinion, without respect for person or title. And that's calling it the way you see it, and that's our job, and it shouldn't matter. The politics of getting to the office shouldn't matter at all. But it's a very good question, and it's a difficult issue to wrestle with as an elected judge in Texas.
I'm told we have time for one more question.
There it is.
Judge Snyder, or Justice Snyder, you brought up the example of sports in the case that was before us today. Respectful that you guys can, or your justices, honorable justices, cannot comment on the case itself. Did you take in consideration the Casey Martin case versus the PGA, and could you comment on that?
No and no. I'm sorry.
All right, that was short, so we'll have one. This is the final question.
But careful, Judge Snyder likes to beat around the bush in his answers.
I was just curious to know why you left the graduate profession there was to pursue a law degree. Oh, you mean why I left teaching? Why I left teaching? Well, I got all my training to be a trial lawyer, so I moved on to law school. If you can survive a courtroom, you ought to be able to survive any trial room in the world. No, I basically, for the same reason that a lot of people did, I basically couldn't make a living, and so I had 2 children, and so I basically went to law school and then went into public service, and I still can't afford anything. But I appreciate the question, and there's not one person here on this bench, I hope I can speak for everybody on this, that have fond memories and owe a lot to the teachers of this world who molded, at least I know, part of my life, or the biggest part of my life. And I think it's a shame more people aren't able to stay there that make such a wonderful contribution.
Well, thank you, Judge Snyder, and thanks to each of you. This is we've enjoyed this day, and we always enjoy these opportunities to visit. And if you want to look on our website, starting no earlier than June, I would say you can look and see how on some Thursday during the second half of this year, this case will probably be decided, and we'll say who won and who lost, and then we'll have, as was mentioned earlier, one or more written opinions that explain in detail why we reached the ruling we reached. So thank you all, and with that, the post-court session is adjourned.
I'll talk to you later.
you'll see yours.
Thanks for coming.
But we enjoyed it very much.
Good, good.